Okay, well, that is not Mr. Ezeala. That is the president of Nigerian Bar Association, whom we have a couple of days ago. So maybe someone still needs to wake up, smell the coffee. Well, Mr. Ezeala, please, let's see you guys. Can we see him so that people don't get confused about who is what?
Maybe it's a semblance.
Mr. Ezeala, good morning and thank you for joining us on the program today. Oh, okay. So I think it's frozen. So we're gonna get him back in that. But there you can see him, but clearly that is not. Oh dear. So you see what Mr. Fabalala might feel if somebody feels. If you know my character and somebody say, can imagine how this might be, or the lighter notes really.
Yeah.
So, but yes, we're going to bring him back and ensure that happens. So,
yes, but there's been plenty of discussion, around the judiciary. I'm glad that Mr. Ezeala is here to discuss this with us this morning.
Yeah.
But only recently, in fact, as a matter of fact, yesterday, the CJN was talking about how the judiciary needs to improve its own its reputation. So I think that we have that report on standby. If the control room can get that to us, that will be very helpful. Okay. Well, it looks like.
All right. Well, we're going to eventually get that report so that we can at least just get them to get some perspectives about that report, because it's not the first time you hear officials, maybe from the bench, even the bar as well, speaking about the perception, the image of the judiciary and how certain things need to happen. So we'll call for that report in a moment. But Mrs. Ezeala, good morning and thank you for joining us on the program today. Can you hear us?
I can't hear anything.
Okay, so we'll sort that out. I can hear you though. Say again?
No, I can't hear you, and I think it's from your station.
Okay, so we'll sort that, because I can hear you clearly right here.
And I am not on mute. No, I can't hear you. Let them. I think I was hearing earlier, but I can't hear you again.
Okay, that's odd, because we can hear you loud and clear here. Okay, so we'll sort that out. And then there's a report which, let's hope you can hear this. Let's set the scene with this one. Just listen carefully to what was said in this particular meeting, and then we'll take it from there.
I can't hear you.
Room of the Court of Appeal is filled to capacity for the annual conference for justices of the Court of Appeal. The ceremony brings together justices of the Appellate Court, the Chief Justice of Nigeria, retired Chief Justices, some ministers, and senior advocates of Nigeria. The Chief Justice of Nigeria tasked the judicial officers to change the dwindling perception of the judiciary.
There is a growing negative perception of the judiciary. We must all individually and collectively work towards changing this negative perception. We look into genuine complaints. We will also stand to support our judges and justices to make sure that where frivolous allegations are made, that there are consequences.
The conference provides a platform for introspection, knowledge sharing, and strategic planning amongst judges, especially amidst allegation of corruption within the justice system.
Justices occupy a position of paramount importance in the administration of justice, and with their decisions exerting a profound impact on individuals, communities, and society at large. Nevertheless, despite our expertise and experience, we are not immune to the limitations inherent in human decision-making, including errors, biases, and prejudices.
Allegations are first made in the social media to the world at large before complainants think fit, if at all, to refer matters to the National Judicial Council. The public and the press pass judgment on these allegations, and all that the complainants appear to require from the National Judicial Council is to rubber stamp those conclusions and punish the judges.
The Attorney General of the Federation and Minister of Justice, Mr. Lateef Fagbemi, emphasized the constitutional separation of powers, highlighting the challenges facing judicial independence.
My lords, distinguished ladies and gentlemen, we must acknowledge, and I do, that challenges to judicial independence persist. These challenges can come from various or multifaceted sources, including but not limited to political interference, public opinion especially perpetrated on social media, and even well-intentioned efforts to improve the justice system. It is, however, imperative that we remain vigilant and steadfast in our defense of judicial independence.
The conference is an avenue for judicial officers to deliberate on issues affecting the justice system and prefer solutions as the court gears towards the 2024-2025 legal year.
Okay, so there you have it, some of the background to what is going on and expectations from the judiciary. So, Mr. Ziala, so let's get on with this one. I hope you did hear that report. So, at this point in time where you see the talk about improving the image of the judiciary, and this, coincidentally, with what's going on about the defamation case between Dele Rotimi and Afe Babala, let me ask you first of all, do you think that these or some of them are veiled narratives or responses concerning that particular matter that is ongoing?
Yes, I think, this time the judiciary will be struggling to extricate itself from the problems that are now created. And then when you go back to criminal defamation, these were the things that the colonial masters introduced to gag our bid for independence. So it's been in the laws for a very long time. And even individuals, private individuals like you and I have been using it to oppress people who believe that are undertrodden. But when you look at the Universal Declaration of Human Rights and you look at African Charter on Human and People's Rights, you will see that that law has become obsolete. And that was why Lagos State government, for instance, had to remove it from the statute book. The state also did. And but it's very unfortunate that some states are still having such laws, or that somebody, for that matter, is still trying to use such law to gag the freedom of any Nigerian. There was a recent case in Burkina Faso, one Konat against Burkina Faso, where the African Court on Human and People's Rights issued its judgment, and among which it ruled that imprisonment for defamation violates the right to freedom of expression. So when you look at all these, you see that we should move a bit faster. The judiciary sometimes are gagged. Now you move from criminal defamation, you go into cyberbullying. What is cyberbullying? Something written in a book, presented to the public. Why don't you see him, even if he's worth 50 billion? So I think the moment we start, and I was thinking that the proper thing would have been, if you have influence in the judiciary, get the matter to move as fast as possible. And you get judgment if you prove your case. But going about trying to cause more problem in the system is something that is antithetical to the system we have. If you look at the Chapter 2 of the Nigerian Constitution, which wholly adopted the Universal Declaration of Human Rights, which is what we are celebrating today, so the state policies should be geared towards respecting the rights of every citizen, no matter whether the person is rich or whether the person is poor or who the person is. That is my take on it. So the judiciary, I think they will start waking up, because you see the speed with which the High Court decided to, give bail. So we'll get there anyway.
Wait, you think, when you say you see the speed with which that was granted, because today, being the 10th, was the day that they had planned a protest about that matter. And incidentally, too, World Human Rights Day. So does that then mean that these chaps actually listen and they know what they're doing when you say that the speed with which it was granted?
Now, you see, when we sleep over our rights, the government or the security agencies will trample on it. Yes, there is threat of protest because people are waking up. If we wake up tomorrow to say, and we're all united, whether the North or the South, and say we want good governance, we want the provisions of Chapter 2, as also we had the precursors of African Charter on Human Rights, the Universal Declaration of Human Rights. If we say today that we want it to be enforced, you will see that the government will wake up. If we say we have a right to development, because what are all these? Now, what is today the slogan for human rights? What are we celebrating today?
Our rights, our future, right now.
Yes, the theme of human rights today is our rights, our future, right now. Right now.
That would have been a perfect fee for the protest.
Yeah, sure. It's just for the protest. And Nigerians are trying to jump in and say, right now, give us our rights. Look at what happened in Ghana. The election took place. The government that was unpopular was toppled through the right channel. The people wanted their rights right now. They have a right to development. They have a right to their future. These are our rights. These are fundamental rights. And nobody should try to take it away from us.
So, but, we're told in the well, I don't want to say Charter of Human Rights now, but when people are teaching people about human rights and how you have a right to this, a right to that, a right to life, a right to, speak, a right to freedom of association, a right to movement, a right to live anywhere in your country, etc., etc. People are also taught that, where your right stops is where the right of another person begins. And that's where we start to speak of violation of human rights. And in recent times, there has been more awareness of how, violations they're not just physical. Violations can also be mental. Violations can be emotional, especially when they're talking, within the context of abuse. Only recently, I think we're concluding the 16 days of activism around sexual and gender-based violence. And these are some of the things that come up. So would you say that, there is a growing awareness? Because this case now that, you raised as an example, is becoming, it does appear that it could be a landmark case for lawyers because it has caused a whole plethora of debates among lawyers as to where does somebody's right start and where does another person's right begin, or where does somebody else's right stop and where does another person's right begin. In your own assessment, where would you say this fine line has been drawn? Yes, somebody has, freedom of speech, but if somebody else is affected by your freedom of speech, should that...
No freedom after speech.
Should that speech be allowed? These are the questions. I don't know. What is your own assessment? Where do you stand?
No, that is why we have the civil law. We have the law of we have the law on defamation, libel, slander, for that matter. We go to courts. When there is now judgment against the person to pay you damages or to retract what he said or to do publication, these are all there for you. So, but resorting to imprisonment, restricting the person from movement, and remember that there can be punitive measures that can take within those civil rights. So why should there be imprisonment if your right is infringed? You already have a remedy. Whatever happens in anything, even if there is murder, maybe careless or reckless murder, there can be a remedy. So if there is a remedy, why don't you follow that remedy? Why don't you follow that civil remedy? Why would you want to restrict the person's freedom? Now, if the matter is in court, for instance, and the person continues with the defamation, because there will now be contempt of court, which will now send the person to prison. Or if there is an injunction from the court to say, Do not continue with this. You say there is now disobedience in court order, so you can be restrained. But when somebody has spoken, I am talking now, somebody now says, oh, that it's criminal defamation. Why? Why should it be criminal defamation? Many lawyers do it. But then, that does not make it right. Even if I do it today, it doesn't make it right. What is right is that, and that is why the courts should also rise to the occasion. Once somebody writes petition against you, criminal defamation, and you're able to come out and you're detained, particularly if you're detained beyond the number of hours or days that you should be, there should be a remedy against the instigator. So, but we must start taking things the right way. We have seen in Europe, we have seen in the United States, this is a verbal assault on you, or this is a libelous assault on you. This is a defamatory thing written in ink. If you remember, during the time of Nnamdi Azikiwe, he was imprisoned, yes, and this is what we are talking about, that it is wrong to follow that in this modern time.
Okay. So
where you're right, like to your question, where the other one also, yes, my right to have my character not assassinated is there. Your right to say anything you want to say is also there. But when you say it and it assassinates my character, you'll be ready to pay me for my character. And it may also include that you should retract and publish in the newspapers that what you said was wrong. Once it's determined by the courts that what you said was wrong. If you send me to prison, for instance, does it make it right? I still need to tell people that, yes, I didn't say it, believing it to be true. I don't know whether you get it. Prison does not solve the problem. What solves the problem is making sure that I pay to the last kobo.
Oh, I don't know, because the argument amongst lawyers has been that, okay, this alleged defamation was committed in Lagos. The book was published in Lagos. Lagos no longer criminalizes defamation. It's a civil matter. But they claim that it's not the same in Ekiti, where the person who was allegedly defamed resides. So I don't know. How do you think that is? I know you've already given a perspective, but in this particular matter now, where I don't know whether you said that Ekiti does not also recognize criminal defamation, but you did mention a number of states, and what we hear from lawyers is that Ekiti defamation is still under criminal law. It's a matter of criminality. Which jurisdiction should have taken precedence?
And well, number one is whether the point is that Ekiti doesn't have it in their criminal law, that I can't say with all certainty. But whether it has it or not, it becomes a law that is a nullity. If they have it, it's a law that is a nullity because it offends the provisions of the Nigerian Constitution. Because the Nigerian Constitution has adopted the Universal Declaration of Human Rights, has also adopted the African Charter on Human and People's Rights. So if there is any law that is inconsistent, any law of the state, of any state for that matter, that is inconsistent with the Constitution of the Federal Republic of Nigeria, or that is inconsistent with the Act of the National Assembly, to the extent of that inconsistency, that law is null and void. So there is no more argument whether Ekiti has it or not. The argument now is even if Ekiti has it, that law is null and void. And that is why if they had allowed the process to go up, if somebody brings it from Ekiti, if somebody brings up that law from Ekiti, it will be an opportunity for the higher courts to nullify that such law, especially when the lawyer in question cites the provisions of the African Charter on Human and People's Rights. We have the enforcement of fundamental human rights provisions, which in itself incorporates the African Charter on Human and People's Rights, also incorporates the Universal Declaration of Human Rights. So what are we talking about again? It's just to go there and quash that law, assuming it's there. Or in any state where it is, just go and quash the law.
Okay, but I want to ask you, because you said we've adopted all of this Universal Declaration, African Charter on Human Rights, which are, laudable things that we have, and we've also, incorporated it into our laws. But we know that, when some of these things are adopted and, incorporated into Nigerian law, we subscribe to these, declarations. We know that we still have the challenge of I'm looking for the word now, but for lack of a better word, localization. So, for instance, you still have states having to adopt and do their own versions of those laws. Clearly, Lagos State has done its own, and there is no question whatsoever about that. Take, for instance, this sexual and gender-based violence, which is something that has been on for a while, which was adopted through the VAP Act. We still had a situation whereby a number of states refused to domesticate that particular act until a campaign was embarked upon, and we saw a number of states begin to adopt what it is that Nigeria federally had adopted. So don't we have to also seek or reach a place where states domesticate this adoption of Universal Declaration of Human Rights, as we have all now subscribed to federally?
Yes, this is where many of us are missing the likes of Honorable Justice Kayode Esho, Justice of the Supreme Court as he was, Honorable Justice Okuta, and many others of that line. I am sure that if these issues get up to the Supreme Court and we have the such minds, they will declare the laws of those states null and void as it regards these areas. Because do you really need some of these laws to be promulgated? Do you really need positive law to enact these ones? No. You have the Constitution. You have the things that support you. So what do you need if you talk about gender violence? What else do you want? If there is no such provision in the local enactment or in the state enactment, you go into the federal enactment. And then remember that criminal matters and the likes are also within the concurrent list. Now, in Nigeria, what do we operate? We operate the exclusive legislative list, we operate the concurrent list, and we have the residual list. So any matter that is within the exclusive list is only within the purview of the National Assembly. And when a matter is in the concurrent legislative list, it means either the national government, this time the federal government, or the state can enact laws on it. And when the national government enacts law on such issue, it takes precedence over whatever the states will have. So it's a question of getting our judiciary lawyers trying to pursue it from that angle. So if you don't have such laws in the states, as long as, and the states did not do anything, these federal laws are supposed to fill the gap. And even if where you have it in the states, but it's not properly done, to the extent in which the state law is inconsistent with the federal law takes precedence over the state law. These issues are not in the residual list. And besides, if there is an enactment of the international community of which we are signatory to, we are bound, whether it's a state, whether as a country. Once you have signed, you are bound. And you cannot say when Nigeria is bound, a state is not bound. A state is a constituent of the federation. So you cannot say, oh, Nigeria has signed, is their business. If we don't enact it, we don't enact it. I think it's timorous souls within the bench that will say, oh, no, we don't have it.
Why then do we speak of domestication? And this is not, this is taking it away from, the delayed Faro TV case now. But I'm just looking at the fact that, there was a huge campaign last year to get a lot more states. It was almost a game of name and shame, for states that had not signed up to the VAP Act. Why did we have to embark on such a campaign if it was taken for granted that as long as we have passed these laws, the National Assembly has passed it, every state should simply subscribe to it? Those laws were binding on the state, but we had a situation where we still had to get the states to sign up to these laws and, remove whatever old laws they had in the states. Where is the place of domestication? What does that even mean within our federal context?
Sometimes some lawyers will say there is a little knowledge gap in all aspects of Nigeria, whether it's in the judiciary, whether it's within the legal profession, or anywhere else, we have a knowledge gap. If you have enforcement provisions as enacted or as provided by the Supreme Court or by the Chief Justice of Nigeria, there, which incorporates the African Charter and also incorporates the Universal Declaration and incorporates any positive law as enacted, which Nigeria is a signatory to. All you need to do is to get to court. The state doesn't have the law. The lawyer goes to court under the enforcement of fundamental rights. And what the lawyer does is to cite these laws, and it will be binding. The judges are supposed to enforce it, mutatis mutandi. And that is all. Yeah, like I said, it's just a matter of, we are campaigning because of some of the people we have in the judiciary, especially at the magistracy level. So that is all, because they will say, where is it in our own law? They do not understand. But then some of these things, you don't need to continue with the magistrates. You go to the High Court, because if your right is being if your right is being trampled upon, enforcement of fundamental rights can only be brought before the superior courts, which is High Courts, Federal High Courts, or any of them. So once you go there and say gender-related violence, once you go there and say sexually-related violence, or any of those ones, and the state doesn't have it, just go to the Federal High Court, use the enforcement of your rights, and you get your relief. The relief you need, you just get it. But the only thing is that, like I say, we don't want to go through all this. We just want to set our mind. But why would even a state, knowing that this law is supposed to apply in this day, why would it not adopt it? These are the type of government, these are the type of governors, these are the type of legislature we have in various states. Legislature that will come in, all they are interested in is what type of vehicle will be given to me, what type of allocation will be given to us. That is all. Tell me why a member of an assembly will not sponsor those bills to have it as laws of those states, knowing fully well that if it's there, and knowing fully well that it will be a bit more difficult for citizens maybe to go to High Court to get it, declared for that state. And even when it's declared, somebody will say it's only binding on the parties within that one, which is wrong. Once a High Court declares it, it becomes a law of that state. Whether the legislature has enacted it or not, that's our understanding of the law. Somebody may want to prove me wrong.
Okay.
But once it's fine.
So help a lot of people also speak to understanding of the law. Yes, yesterday, part of what you also referenced in passing, Mr. Dele-Rotimi has been granted 50 million naira bail. He's supposed to submit his passport. In that case, that was filed against him. Also, as we did see at the Federal High Court in Ado-Ekiti by the IGP. So that has got a lot of tongues wagging up until this morning. Several people don't understand it, because now that video, which as a result of which went viral while he was arrested. So you see people commenting, saying, now they're asking that why is it that Mr. Dele-Rotimi was granted bail bond of 50 million for this kind of case? And then two things, they also now started tweeting pictures of Mr. Rotimi in cuffs, and then they referenced the former Kogi State governor who was not in cuffs. They say they don't understand it. So could you explain to them, or to everyone who's listening, why does one have to be in cuffs and the other not in cuffs? In fact, they think that the other has a more serious case or question to answer, but is not in cuffs.
I think it's the police that can answer that question, because the other one is EFCC, which seems to be a bit more reasonable. You have no business putting anybody in cuffs, especially when you do not reasonably believe that the person will be harmful to others or the person will not run away. Why would you put a legal practitioner in cuffs for such a matter? So it doesn't accord with reason, So whether it's the former governor or Brother Dele, none of them should be in cuffs. But it is an evidence of a failed system. It is one of the symptoms, in fact, the gross symptom of a failed system, a failed state, no longer a failing state. Ordinarily, when this type of thing happens and the police does this type of thing, the IG of police should be able to call on those who that have done this to discipline them. Why should this be? Can you explain why a citizen, anybody for that matter, it's only when there are issues of murder, armed robbery, that is when you should put people in handcuffs. Once there is no issue of violence, it's so that, because what you're doing is the crime is such serious. If it's armed robbery, murder, the crime is so serious that the person may want to escape. Now, the issue of 50 million, I mean, he is not expected, or the person taking him on bail is not expected to deposit 50 million. The only person, is supposed to post bond for 50 million to say, oh, if he runs away, I'm going to give you 15 million. That is it. So even though still I believe that the judge that issued 50 million is still on the high side. I mean, this type of thing, he should be granted bail on self-recognition. Why will he run away?
So,
I mean, what are they looking for him? He's around.
Two things on that matter. For the cops, what do we need to do? Because this is not the first, again, that this kind of narratives are coming through. We've seen this before, and yet it happened again. Does anything need to be done differently, or change the statutes, or spell some things out expressly to determine who and when one can be in court? Because if we keep leaving it at the discretion of the police, these kind of things might come up again.
No, I think, but the lawyers know what to do. I think the lawyer should specifically sue the police for putting him on course. Let the police explain why, how, what is the yardstick. Yes, somebody said that somebody was saying that he was invited, he refused to come to Ekiti State. I read it in one of the things people said, but if he was invited, he refused to come to Ekiti State. He said, I am here, come and take me. If you want me to come, that's fine. Let them come and take him. There is no evidence to show that if they had taken him, that he was going to be violent against them, he was going to do anything. And having taken him to prison and moving him from prison to any place, is there still evidence that he's going to attack the police? One person, how many police can he attack? So I think it's important at this stage for his legal team to look at that particular, there are items of it, enforcement of his fundamental rights. Let's believe that the courts can make pronouncements on the legality of any person being handcuffed. So I think it's very important.
About the bail bond, what are the factors, the preceding factors, what do they consider? What factors do they consider before they decide this is the bail bond that I'm going to request that they post?
Now, this is at the discretion of the courts. I will first commend the courts that I understood granted bail even orally. Many judges will not agree. They will say, file your motion. But you can see, like I said, it is the masses that made the judge to even agree to grant bail, even orally, on oral application.
You said the masses?
Yes, the threat of protest, the whole thing in the media, whether nationally and internationally. When you look at the pulse of the people, it becomes easier for you to exercise proper discretion in what you are doing.
So why did they tell us that what happens in the court of public opinion doesn't necessarily affect what happens in the court proper?
There is no place where public opinion does not change policies. There is no place. Look at the Syrian uprising. If you look at every uprising, if you look at Kenya, if you look at South Africa, in the United States, same way. There is no place. Public opinion as well. If all Nigerians are united to say this is wrong, any government will run because it can bring down.
Except in the last presidential election. You remember what the judges said? They were lampooning those who went on social media, trying to impugn the integrity of the judges preceding that judgment.
Yes, they did. And as far as they were thinking that it's not that is not the majority, that is those that have access to the media. But they knew it affected them. And everybody knows that once you go to the public opinion and the public buys it and the public understands that this is wrong, there is no government who can stand public opinion anywhere in the world. No government anywhere, even the military government, have not been able to stand public opinion in many places. So is it a civilian government that will, or the one that called itself a democratic government that will stand public opinion? Look at how the former South African government left office. Look, just everywhere. So public opinion, that is why we must always ask Nigerians to be steadfast. Be steadfast. It is also public opinion that made Nigeria not to be worse than what it is today. If we had all gone to bed, if the media had gone to bed, everybody has gone, Nigeria would be worse than what you're seeing today.
So I want to ask you quickly, if you were to use this as a yardstick then, I don't know whether you consider it a fair yardstick though, to look at the state of human rights today in Nigeria, where would you say that we need to really put some work to improve our ratings on human rights?
Number one is that the government should be out to say, yes, we want to respect human rights. The agencies that are connected to individuals should also be up and doing. There should be punishment for infringement of human rights. Today, when you take the police to court for infringing your rights, even if judgment is given to you, nobody gives you anything. So the government should be ready. And I had advocated, time without number, that once your rights are infringed upon, whether by police, whether by EFCC, and I said lawyers should sue those police officers directly, if he's commissioner of police, if he's EFCC chairman, if he's IC, whoever, sue them directly too, apart from the organization they are representing. Because the rule is, once you are outside, not being according to the law does not protect you, even as IGP.
We're going to anchor at that point. Thank you very much indeed for talking to us this morning on the occasion of the World Human Rights Day, Mr. Chukwuma Isiala, legal practitioner.
Thank you for inviting me. I appreciate it. And thank you to Nigerians for listening.
All right. So let's go on now for Business Morning. Will be coming up on the hour.